Modern Real Estate Practice, page 166. Customer level services. Even though an agent's primary responsibility is to the principal, the agent also has duties to third parties. When working with a third party or customer, a real estate professional is responsible for adhering to state and federal consumer protection laws, as well as the ethical requirements imposed by professional associations and state regulators. In addition, the real estate professional's duties to the customer typically include reasonable care and skill in performance, honest and fair dealing, and disclosure of all facts that the real estate professional knows or should responsibly be expected to know that materially affect the value or desirability of the property. Opinion versus fact. Real estate brokers and sales associates must always be careful about the statements they make. They must be sure that the consumer understands whether a statement is an opinion or a fact. Statements of opinion are permissible if not made carelessly and there is no intention to deceive. Statements of fact, however, must be accurate. Exaggeration of a property's benefits is called puffing. While puffing is legal, real estate professionals must ensure that none of their statements can be interpreted as fraudulent. For realtors, puffing is considered unethical even if it is legal. Fraud is the intentional misrepresentation of a material fact in such a way as to harm or take advantage of another person. That includes not only making false statements about a property, but also intentionally concealing or failing to disclose important facts when there is a duty to disclose. In practice, while showing a potential buyer an average-looking house, the sales associate described even its plainest features as charming and beautiful. Because the statements were obviously the sales associate's personal opinions designed to encourage a positive feeling about the property or puff it up, the truth of the statements is not an issue. The misrepresentation or omission does not have to be intentional to result in real estate professional liability. A negligent misrepresentation occurs when the real estate professional should have known that a statement about a material fact was false. A real estate professional's lack of awareness of an issue is no excuse. A misrepresentation due to the professional's carelessness will make the professional culpable, which means subject to liability. If the buyer relies on the real estate professional's statement, the professional will be liable for any damages that result. Similarly, a real estate professional who accidentally fails to perform some act, for instance, forgetting to deliver a counteroffer, may be liable for damages that result from such a negligent omission. Simple negligence can result in an accidental misrepresentation, and while some damages may result, they may be covered by the real estate professional's errors and omissions insurance. An agent owes a customer the duties of responsible care and skill, honest and fair dealing, and disclosure of known facts about the property. page 167. Disclosures. As part of the recent trend for more consumer protection for purchasers, many states have enacted statutes requiring the disclosure of known adverse property conditions to prospective buyers. Generally, these apply to sellers of residential properties, often for those 1 to 4 dwelling units. Pre-purchase structural inspections, termite infestation reports, or other protective documentation may also be used. The actual disclosures that sellers are required to make vary according to each state's law. Environmental hazards. Disclosure of environmental health hazards which can render properties unusable for the buyer's intended purpose may be required. For instance, federal law requires the disclosure of lead-based paint hazards. Frequently, the buyer or the buyer's mortgage lender requests inspections or tests to determine the presence or level of risk. In practice, real estate professionals are encouraged to obtain advice from state and local authorities responsible for environmental regulation whenever the following conditions might be present: toxic waste dumping, underground storage tanks, contaminated soil or water, nearby chemical or nuclear facilities, and health hazards such as radon, asbestos, and lead paint. Property conditions. In residential transactions involving property of up to 4 units, the seller typically has a duty to disclose any known defects that threaten structural soundness or personal safety. A latent defect is a hidden structural defect that would not be discovered by ordinary inspection. Buyers may cancel the sales contract or receive damages when a seller fails to reveal known latent defects. The courts also have decided in favor of the buyer when the seller neglected to reveal violations of zoning or building codes. Increasingly, however, there is a growing trend of not only the right but the responsibility of the buyer to discover any material problems with the property. Some states allow the seller to provide a non-disclosure statement to the buyer that places the burden of discovering any adverse property conditions on the buyer. In addition to the seller's duty in most states to disclose known latent defects, in some states, the agent has an independent duty to conduct a reasonably competent and diligent inspection of the property. It is the real estate professional's duty to discover any material facts that may affect the property's value or desirability, whether or not they are known to or disclosed by the seller. Any such material facts discovered by the real estate professional must be disclosed to prospective buyers. If the real estate professional should have known about a substantial defect that is detected later by the buyer, the real estate professional may be liable to the buyer for any damages resulting from that defect. In practice, a broker knew that a house had been built on a landfill. A few days after the house was listed, one of the broker's salespeople noticed that the living room was uneven and sagging in places. In some states, both the broker and the salesperson have a duty to conduct further investigations into the structural soundness of the property. See Easton versus Strasburger, 152 Cal App 3D 90. A 1984 California case. In other states, no such duty exists, but the broker and the salesperson would have the duty of discussing the issue with the seller and advising the buyer to have an inspection performed. They cannot simply ignore the problem or place throw rugs over particularly bad